a bit about technical difficulties, but fortunately we are live now. So today we are delighted to have with us Gregory Schaefer, Chancellor's Professor of Law and Political Science at the University of California Irvine School of Law, to present his latest book entitled Emerging Powers and the World Trading System, the Past and Future of International Economic Law. And I have it here with me. And I have to say that this is a fantastic book, and I highly recommend that you read it in case you haven't done so already. The book addresses a question that is critical to the trading system today, which is, how has the international trade and broader economic legal order changed since the WTO's creation because of Brazil's, India, and China's rise and their development of trade law capacity? The book also addresses in detail 3 specific questions. 1, how did these countries invest in trade law capacity to defend their interests at the WTO? 2, in doing so, how did these emerging powers change internally? And 3, what are the implications of this development for the WTO and the broader trade and economic governance? So these are some of the themes that Greg will be addressing today. After Greg's initial presentation, we have 2 excellent discussants who will share with us their views on these topics. They are Chad Bown, Senior Fellow at the Peterson Institute for International Economics, and Kristen Hopewell, Canada Research Chair in Global Policy in the School of Public Policy and Global Affairs at the University of British Columbia. We will also like to bring our audience into our discussions, so please send us any questions that you would like us to address. So without further ado, let me now bring Gregory in. Greg, the floor is yours.
Great, thank you, Annabelle. Thank you so much. I greatly appreciate it. Hello, everybody. So this is a great pleasure to speak to everyone. I wish, of course, this was not a time of COVID, in which is the reason why I'm speaking from here and not live in Geneva with you and with friends. The book is, let me speak a little bit, and let me also just say thanks to my friends Chad and Kristen. This is, I can't imagine 2 discussants that I would rather have on this panel. So let me say a little bit about the genesis of the book. The project behind the book started from the question of how developing countries could build trade law capacity to defend their interests in a system largely developed and dominated by the United States and Europe. The project's focus evolved over time as it became apparent that by building legal capacity and engaging with the trade system, these 3 emerging economies, Brazil, India, and China, were transforming themselves. It became further evident that when successful, they were also affecting the trade legal order itself. You can see how the book studies both the national and international levels and how they impact each other. It is through the study of these intermeshed processes that we can better understand the central conundrum and paradox that the book addresses. How is it that the United States has called into question the trade law system it created, while emerging economies that long criticized that system for its bias in favor of the United States now defend it? Let me say a bit what lies behind the book. The short answer is about 20 years of work, as Chad knows, as he has seen me engage with these questions over time. The study included early quantitative work on the importance of legal capacity in trade dispute settlement, which I published with Mark Bush and Eric Reinhart in the World Trade Review. But mostly it involved qualitative interviewing on trade policy making and dispute settlement in Brazil, India, China, the United States, and Europe, including interviewing many people here in Geneva. At the core of the books lies this paradox, which is why the United States, which was central to creating the WTO and its binding dispute settlement system, has now undermined that system. The WTO largely reflected US law and US preferences more than any other country. Other countries, in contrast, had to change sometimes thousands of laws and regulations and create new institutions. The prediction across the social sciences is that emerging powers will be the revisionist ones, and incumbent powers, like the United States, will try to defend and retain the system that they created. But in the case of the WTO, the opposite has happened. The United States has become the revisionist power, neutering the WTO's dispute settlement system, and China, Brazil, and India now defend it. The book investigates why. We all know the economic and political narratives which dominate discussion. Economists like Richard Baldwin have brilliantly identified the impact of the revolution in information and communications technology in the 1990s, which led Western firms to outsource production of goods and services to countries like China and India, creating a new unbundling of production through global supply chains. China became the manufacturer for the world. Western firms outsourced services, including legal services, to India. China's economic growth triggered a commodity boom for Brazil's agribusiness and mining sectors. These economic shifts catalyzed dramatic shifts in shares of global GDP, resulting in a relative shift of economic power. So what about law? The book's central contribution is to trace how these countries developed what I call trade law capacity, to take on and challenge and go lawyer to lawyer, expert to expert with the United States and Europe, whether in the negotiation of new rules or litigation and settlement under existing rules. They invested in broad-based trade law capacity and were able to use the system to challenge the United States to its consternation. The book investigates how these countries adapted their institutions and developed new professional expertise, both within and outside of state institutions. This included the development of new think tanks, academic specialization, the private legal bar, civil society organizations, networks among them, as well as new standard-setting institutions, intellectual property institutions, and import relief institutions. The result was enhanced state capacity within these countries. If you think about how the development of infrastructure was central to China's economic success, trade law capacity represents a form of infrastructure. Here are 9 ways trade law capacity matters that the book documents. Drafting and negotiation of international trade rules, the rules of the game. Monitoring of foreign compliance with commitments so that you can identify problems. Bringing legal complaints. Shaping terms of trade effects affecting a country's social welfare. Shaping the meaning of texts. Trade jurisprudence, trade litigation affects the interpretation, application, and social understanding of the law over time, thus shaping the meaning of obligations. A text meaning is not simply natural, but it is a construction developed within a contested community of interpreters. Legal actors contest to take control of the text. Bargaining in the shadow of the law, which affects future negotiations by shifting who needs to negotiate changes in light of legal interpretation of vague rules on the one hand, and the strategic pursuit of settlement in discrete cases on the other hand. 7, protecting domestic policy space for developmental and regulatory initiatives in which legal capacity is central. Relatedly, 8, warding off capture by protectionist sectors, where one can refer to WTO rules. And 9, and perhaps underappreciated, triggering spillover effects such as catalyzing a greater role for a country's lawyers in international private law settings. As the general counsel for a major Chinese state-owned enterprise, whom I interviewed, stressed, the WTO changed every side of our life, including our habits and our practices. Building trade law capacity is not a simple matter. The book traces how these three countries did so, each in unique ways in light of their national and local contexts. The result was greater professionalization of the trade bureaucracy, greater coordination among ministries, greater investment in trade-related professional careers, greater coverage in the media, sparking popular and professional interest, changes in academia with new courses, moot courts, cutting-edge research. In China, amazingly, between 2007 and 2014, 2/3 of all funded research proposals were for international economic law topics. A greater role of lawyers in trade, the growth of the private bar regarding trade. The book starts with a quote from a private Chinese lawyer that is an epigraph to chapter 1. It's a lawyer, Chinese lawyer from a major Beijing law firm who said, "We are in the history. We are making the history." Changes in the private sector with new specialists, new think tanks, new trade associations, and then public-private partnerships between the private sector and the government. The result of these transnational processes was not the weakening of the state, not its weakening, but rather the strengthening of state capacity to play an active role internationally in the legal ordering of trade. Brazil, India, and China used mechanisms of public-private coordination to gather information and define and advance government and constituency interests in trade negotiations and dispute settlement. They adopted mechanisms analogous to those first developed in the United States and Europe, but these mechanisms now reflected their own institutional heritages and constraints. They reinvented and they repurposed US and EU models of public-private coordination while transforming themselves in the process. And the WTO had huge impacts in these three countries. Emerging powers' deployment of trade law capacity in turn shaped the trade legal order in multiple ways. As regards WTO negotiations, it enabled them to thwart US and European proposals, shape new negotiating initiatives, and become critical for any agreement's conclusion. As regards monitoring and litigation, it empowered them to launch or threaten to launch legal cases, including against major trading powers. Where successful, they could spur change in foreign regulatory practices that were the subject of dispute, and they could shape the interpretation of WTO legal texts in systemic ways that affect regulatory practices more broadly across countries. As regards implementation, it facilitated their design and application of regulatory and trade policy. The impact is encapsulated in a quote from an EU diplomat regarding China, whom I interviewed. He said, "China knows how the WTO works. It does not hesitate to threaten bringing a WTO case. For the Commission, it creates more challenges in the relationship. They know, and they know we know they know." Of course, these countries' deployment of legal capacity linked with other developments, including shifts in US employment patterns, the US decline of manufacturing, the rise of inequality in the US, which have affected the trade legal order. Emerging powers' deployment of legal capacity in the WTO linked with structural changes affected the international trade legal order by giving rise to broader economic nationalist shifts in the United States. These countries' ability to counter the United States and Europe, coupled with US perceptions of China as a geopolitical threat, was a major contributing factor to US disenchantment with the WTO, manifested in US attacks on its dispute settlement system. The inability of the United States to change WTO rules through WTO political processes, coupled with WTO appellate body decisions not to its liking, catalyzed the collapse of the dispute settlement system. The book complements its study of Brazil, India, and China with a chapter on US responses to the trading system. In sum, the book shows how law and policy at the international and national levels mutually implicate each other. Developments in one cannot be understood without attending to the other. International trade law has deeply implicated Brazil, India, and China. The relative rise of emerging economies, in turn, is deeply implicating international trade law's future. So let me just say a few last words about how they were able to shape the trade legal order in interconnected ways. First, through their investments in trade law capacity, these countries collectively countered US and European dominance in the trading system through WTO negotiations and dispute settlement. Unfortunately, they contributed to the stalemate, or this contributed to the stalemate at the WTO as a negotiating forum. Second, stalemate at the multilateral level led the United States and European Union to turn to regional and bilateral negotiations, and thus fragmentation of the trading system. In 2003, USTR Bob Zoellick announced that the United States would pursue free trade agreements with can-do countries, ones that would constitute a new coalition of the willing. The aim was to create new templates, such as regarding goods, services, and intellectual property, and now e-commerce. In response, emerging economies developed their own models and initiatives through regional and bilateral trade and investment agreements. Most notably, China is using its trade law capacity to develop its Belt and Road Initiative and potentially create a Sino-centric economic order. To support this initiative, China is expanding a web of trade and investment agreements that led to the conclusion of the Regional Cooperation Economic Partnership for Asia. Third, it has led to the collapse and the potential demise of binding multilateral dispute settlement, at least to a WTO appellate body. This challenge still besets us. So for there, I'll leave off and turn it back to our commentators.
Thank you. Thank you very much, Greg, for that presentation. Let me now turn it over to Chad for his comments. Chad?
Thanks, Annabelle. Thanks for the invitation to be here. Hi, everybody. For those of you there in Geneva, miss being there in person, and for everybody online, thanks for tuning in. So for anybody who doesn't know me, I should warn on you that I'm an economist. I'm not a lawyer, though I do oftentimes play one on a podcast. But the reason I should also tell you full disclosure, the reason I am able to play one on a podcast is because of Greg. Greg has had a huge influence in my career, whether he would like to admit it or not. I first met him, I'm trying to remember exactly when, it was 1996 or 1997. I was a PhD student in the economics department at the University of Wisconsin. Greg was a professor of international law at the Law School of Wisconsin. And my advisor said, you know what, if you're actually interested in this WTO stuff, you should go take the trade law and actually learn about this. So I went over and I took Greg's class. And I was incredibly annoying because I was the one that wanted to ask the detailed questions about when we were covering anti-dumping. What is this zeroing thing? Explain this to me from the front row. So sorry about that, Greg. And please, everyone else, don't hold him accountable for my butchering of of trade law over the years. He did his best. More seriously, though, Greg has had a profound impact for a number of us, but me especially, through his research. This book is the latest installment of that, but I think it's important to put this book into context. So the first really, really impactful piece of research of Greg's that shaped my thinking in my own research trajectory was his Brookings Institution Press book, Defending Interest, Public-Private Partnerships in WTO Litigation, which I think was 2003 or so, explaining how WTO litigation was working for the United States and the EU. I was a naive academic. I read the book, was inspired by it. It got me thinking, so much so that I decided to write my own book. But mainly it was to try to please Greg, or to not necessarily please Greg, because I have often found over the years that I disagree vehemently with some of Greg's results and the implications of what he's saying. They provoke these questions in my mind, and that's my initial reaction as an economist, to disagree with them. But then I do my own research and oftentimes come to the conclusion that, yeah, Greg was right. So I'll get more to this, because there's certain elements of the current book that have provoked profound disagreements at the moment. And yet at the same time, I feel like once I dig into them myself, I may settle on where Greg ended up as well. But let me walk us through some other things before we get there. I think Greg is obviously unique, and this book is unique in the ability to weave together, obviously, the WTO stuff, which is the critical foundational element to all of this in terms of the law, the institutions and treating things seriously, the understanding of political economy, the understanding of how law firms work, of how international organizations work, of how civil society and think tanks and the litigation process works. All of this stuff I learned over the years, but mainly through Greg in his research. And what he has done in this book is to show how sort of the model that originally developed in the United States, in Europe, then kind of proliferated to Brazil, to India, and ultimately China, has sort of been adapted to fit the local circumstances along the way. And that requires a tremendous amount of research and knowledge, not only in the law and the WTO stuff, but really on the ground reporting and talking to people in each of these different areas. And he has a gift to do this, and it comes through clearly in this book. I want to just read kind of one example. We can do a full book reading here from page 205, talking about the Chinese context and how they've ultimately chosen to handle their tremendous litigation under the WTO over the first 15 years or so of their involvement. And for me, as an outsider, I was always curious. It seemed to be that they were hiring these external law firms to help litigate their cases, and I was wondering why. Right, this isn't the model, say, that exactly the United States or the EU was adopting. But he says on page 205, in these cases, the foreign law firm takes primary responsibility for the legal analysis, while the Chinese firms assist primarily with a factual presentation of the relevant Chinese measures. A Chinese lawyer quips, the Chinese law firm collects the ingredients, while the foreign law firm cooks them into a dish. I think that's a very nice example of how the real world works in practice, presented in a way that not only legal practitioners, but also non-legal folks like me, political scientists as well, can understand. Lastly, on my personal experience about the importance of WTO legal capacity, because my priors going into engaging with Greg's work was always that you can outsource all this kind of stuff to the private sector. Why do you need to build this legal capacity internally? It really took my own government experience to have it hit home for me. And so when I went and worked, I was 15 years into my career before I saw this. When I went and worked in government in the United States, and saw the role that USTR plays in the interagency process in the United States. So the promulgation of new new regulations, and having USTR be in the room in the policymaking process, saying, yeah, we need to think about the WTO consistency of what we're proposing here, because we could face, retaliation and those sort of costs that we need to take into consideration, right? And it has, in its best form, an actual huge impact on the domestic regulatory process, having that WTO legal capacity in-house in a government that I only came to appreciate by seeing things on the inside. So another lesson learned from Greg. Okay, so lots of nice things. Do read the book. It's amazing. I highly recommend it. But I want to make not quibbles. I have a couple of thoughts, things that came to my mind, maybe that I disagree with, but I wanted to kind of poke Greg on having read the book. And I didn't give these to him in advance. So I didn't warn him that these were coming. So the first, let me see if I can share my screen. And I'm always hesitant to kind of do this because it's likely to, screw things up. But I wanted to show a chart. Can you see my screen? Yeah, okay, good. So this is a chart from a paper that Samaya and I did about a year ago called Why Trump Shot the Tariffs, the End of WTO Dispute Settlement. So the last chapter of Greg's book is sort of, talks through the implications of these emerging markets having developed all this legal capacity and how this may in and of itself contributed to some of the downfall of the system, or the way the United States especially has become upset with the system. So here's a data point that I don't think has been brought up enough. So yes, it's absolutely true that China has had its fair share of disputes on the defendant side, kind of as a share of its amount of trade in the world. It's kind of what you would expect. But what's not true is that has been evenly dispersed across China's trading partners, right? So China is a huge import market and kind of the biggest, or one of the top import markets for lots and lots of countries' exporters. But when I looked at the data, the thing that jumped out to me is the only country, the only trading partner of China that's really willing to bring cases against China at the WTO to hold its feet to the fire when it comes to commitment issues has been the United States. Yes, there have been co-complainant cases brought, that the Europeans have come along for the ride. The Japanese have brought coming along for the ride, Canada, Mexico. And these countries have brought their own cases when China did, a very specific anti-dumping case against their firms that they wanted to fight, where they could be the only litigant, fine. But on the systemic issues, whether it's Chinese subsidies, IP, it was really only the United States bringing other countries along that brought those cases forward. And this is just not true for the other economies in the trading system, right? We have no problem, anyone bringing cases against the United States or the EU, name your tiny country. So what is it about the Chinese system that have made other countries so fearful and hesitant about bringing disputes against China? I don't know the answer to that question, but it's definitely a frustration that I think the United States has come across with its dissatisfaction. So this issue of kind of, the WTO being unable to hold China to account, the United States tried, arguably, but other countries kind of didn't play their part. So that was one point. Second question that I'm sort of left with. So and I think, Greg, when I took your class back in 1996 or 1997, and you introduced probably on the first day the GATT agreement, I think it was 96 pages. And then I remember subsequently reading later on in the book by Genesis, The Origins of the GATT, by Petros Mavroidis, Doug Irwin, and Alan Sykes, that economists actually played a large role in the interwar period of sort of drafting the GATT. Subsequently, the WTO has become much more legalistic, right? Robert Hudek, that I think, the great legal scholar that all of us interdisciplinary and multidisciplinary folks aspire to try to be more like, had this quote, and I'll get it wrong, about, you know, the GATT being diplomats' jurisprudence or something, and the WTO being the lawyers' jurisprudence. So my question for you is, how much of where we've ended up now at this point, where the WTO is stuck, is your fault? Not you, but the lawyer's fault. That we've gotten too far away from the balancing of the role that economists play, and especially politics play, and making sure that this organization can get through things. How did we push things and make it ultimately too legalistic in ways that were ultimately not sustainable? So those are my two hopefully provocative questions. Again, some of my best friends are lawyers, so I'm hoping that I make them all mad at me with that. But this is a really great book, and thanks for the opportunity to be a part of this with you.
Thank you. Thank you very much, Chad, for your comments and for those two questions. I hope we will be able to come back to them. Kristen, now over to you, please.
Great. Thank you. Thank you for inviting me to participate today. It's a pleasure to be here and to have the opportunity to engage with this extremely rich and interesting book. I have to say, this is a truly impressive piece of scholarship. It's both highly ambitious in its breadth and scope, as well as very carefully and exhaustively researched, providing an extraordinarily detailed and nuanced analysis of how emerging powers are shaping international economic law in the trade regime. So the book really makes for fascinating reading. For anyone who hasn't yet, I would really encourage you to get a copy and have a read. I would say that this is really essential reading for anyone interested in understanding how contemporary global power shifts are playing out within and affecting the WTO. So the book's central argument that the emerging powers' investment in trade law capacity enhanced their ability to defend and advance their interests in the trading system in both negotiations and dispute settlement, I think is extremely well documented and very compelling. Greg does a masterful job of demonstrating how the development of legal capacity was critical in enabling Brazil, India, and China to translate or channel their newfound economic might into real power within the WTO system. So what I want to focus on is actually the central puzzle that the book is framed around: how it is that the US has become the disruptor in the multilateral trading system and the emerging powers, the defenders of the system. So as Greg mentioned in his introductory remarks, there's this surprising paradox here, where the US, who was once the chief architect of the multilateral trading system, has now become increasingly dissatisfied with the system and is now threatening the very system that it once created and led. Whereas emerging powers, who've long complained that the multilateral trading system was biased against them, have now, Greg argues, become the chief defenders of the system. So this seeming contrast between the US as a disruptor of the multilateral trading system and the emerging powers as its defenders provides the starting point for the book and is the central puzzle that it seeks to address. And I think the book does a fantastic job of charting how and why the US came to pose such a threat to the trade regime and explaining what's behind its behavior, including how it's linked in part to the development of trade law capacity amongst the emerging powers. There's no question that under President Trump, the US launched an unprecedented assault on the multilateral trading system, arbitrarily imposing tariffs on all of the US's major trading partners, launching a trade war with China, using the threat of tariffs to extract non-trade related concessions from other states, using the threat of withdrawing from bilateral and regional FTAs to force other countries to renegotiate those agreements and make one-sided concessions to the US, imperiling the WTO dispute settlement mechanism by blocking appellate body appointments, and of course, repeatedly threatening to withdraw from the WTO. So what we've seen is the US blatantly violating the rules and principles of the multilateral trading system, abandoning trade multilateralism in favor of aggressive unilateralism, and weaponizing trade as an instrument of economic coercion. And despite President Biden's professed commitment to multilateralism and international institutions, we've actually seen little change in US trade policy under his administration. So as Greg aptly puts it in the book, quoting a negotiator from the WTO, the US has effectively taken a wrecking ball to the multilateral trading system. And the argument he makes about why that's occurred why it is that the US has become such a disruptive force in the liberal trading order, I think is very clear and very convincing. But what I want to probe is that contrasting characterization of the emerging powers as the defenders of the system. First, I'd argue that it's important to disaggregate and distinguish between the emerging powers, as Brazil, India, and China, I think, have each been behaving quite differently in the trade regime at the current historical moment. Focusing on China, which is a central focus of the book, certainly since the World Economic Forum in Davos in 2017, China has very much sought to portray itself as a defender and champion of the rules-based multilateral trading system. But I think it's important to separate rhetoric from reality here and look a little bit more critically at its actual behavior on trade. China, just like the US, I would argue, has also been endangering the multilateral trading system. The core principle of the WTO is that trade should be governed by the rule of law rather than the raw use of power. But like the US, China has also shown a flagrant disregard for the rule of law in trade. It too has been weaponizing trade as an instrument of economic coercion against weaker states, in blatant violation of the rules and principles of the multilateral trading system. There are many examples of this. Recently, for instance, in retaliation for Canada's participation in the Huawei extradition case, China blocked imports from Canada of a number of agricultural commodities, including pork, beef, soybeans, and canola. These trade restrictions cost Canada an estimated $4 billion in lost exports. And China has similarly blocked imports from Australia in retaliation for its calls for an independent inquiry into the origins of the COVID-19 pandemic, as well as Canberra's complaints about Chinese Communist Party interference in Australia's domestic politics. As Australia's largest trading partner, accounting for nearly 40% of its exports, China's import curbs, which target an extraordinarily broad list of agricultural and mining products, are intended to inflict maximum economic pain on Australia's core export sectors. And these cases are far from unique. A growing list of countries around the world have been targets of China's trade aggression. Beijing has used the threat and imposition of trade restrictions to punish over a dozen countries for various perceived affronts. And what we've seen is that WTO rules have proven entirely inadequate to prevent this behavior. So increasingly, both the US and China seem to simply ignore the rules. Now, the basic precondition for the WTO to function is that states are actually willing to be bound by the rule of law in trade, but that no longer appears to be the case for either the US or China. Instead, their approach to trade appears to be driven by Thucydides' maxim that the strong do what they will and the weak do what they must. Both have been engaged in aggressive unilateral trade actions, using their economic might to bully other states. So we now have a situation where the two dominant powers in the multilateral trading system, the US and China, are both effectively behaving like rogue states in the trade regime. So the book makes a strong case, and I would certainly agree that we're at a pivotal moment for the future of the multilateral trading system. Greg characterizes the key conflict today as a debate between more law or more policy space. That is, whether WTO rules should be expanded specifically to better address China's model of state capitalism and constrain its heavily interventionist industrial policies, or whether there should be greater scope for industrial policy and state intervention under WTO rules. I would argue, though, that that's defining the central problem facing the trade regime through a fairly narrow lens of US-China trade relations and rivalry. But of course, there are 162 other countries at the WTO, and if we broaden out to consider the perspective of the rest of the world, things look slightly different. For many countries, one of their biggest concerns is growing trade aggression and economic coercion from both the US and China. So the key question and priority for many is therefore whether global trade rules and their enforcement can be strengthened to rein in the behavior of dominant states and prevent aggressive unilateral trade actions and the arbitrary abuse of power. If powerful states refuse to abide by global trade rules and openly violate the rules when it serves their interests to do so, the rules themselves risk becoming meaningless. So the multilateral trading system is at a critical juncture, facing the danger of a descent into lawlessness where the rules cease to have any meaning and are no longer able to constrain state behavior. The key choice for the multilateral trading system, I would argue, is therefore between more law, specifically to prevent aggressive unilateralism and economic coercion, or the risk of this descent into lawlessness. So the big question, of course, is where we go from here. And as we've seen historically, crises can sometimes operate as turning points, opening up possibilities for reform. We've seen this before in the multilateral trading system, which experienced a similar crisis in the 1980s when a rising wave of protectionism threatened to pull the trade regime apart and potentially cause the system to collapse. Instead, what occurred then was just the opposite. Out of the turmoil of the 80s grew the Uruguay Round and the creation of the WTO, representing a dramatic expansion and deepening of the rules-based multilateral trading system. So in terms of the current crisis, it's clear that we're on a precipice. And the question is whether we'll see the system collapse or a deepening and expansion of the system, a strengthening of its rules and their enforcement, and a renewed commitment to a rules-based trading order. So I'll wrap up there, and thank you again for the opportunity to engage with this extremely rich and provocative book. There's so much to discuss and debate that we really can't do it justice, and the depth and the nuance of its analysis in just the hour that we have. But again, if you haven't had the opportunity yet, I'd strongly encourage you to pick up a copy of the book and give it a read. So thanks very much.
Thank you, Kristen, also for your fantastic comments. I would say that even though we have a short period of time, I think a lot has been said to entice everyone listening and watching us to actually read the book. So we have some 10 minutes left. So I want to go back to Greg and ask him. So Chad posed a number of two very interesting questions, and I'd like to turn it over to you and hear your responses, Greg.
Great. So I'm going to take the second one first, which was it's all my fault, and say, no, actually, it's all Chad's fault because of Chad's influence on me. And of course, I'm not speaking just about Chad, I'm speaking about economists. I think what's happened, and this goes to Kristen's last point as well, is what's happened is that the WTO dispute settlement system did a relatively good job after Seattle in particular, and before, of balancing sort of the interface between environmental concerns, animal welfare concerns, creating sort of greater space than what had been understood before for legitimate national policies to address these challenges. And the major sort of critiques of the WTO, they diminished. And that was actually a great success of the WTO appellate body and its dispute settlement system. So Chad, of course, is right that there's a mismatch within the WTO, as everyone knows, between sort of a dysfunctioning political / quote legislative process of updating rules and a dispute settlement process. And one can then understand why countries would be upset if they feel that something that they've negotiated has been interpreted in a way with which they vehemently disagree, and they cannot change that through a political process because of the consensus rule. So that lies at the heart of a challenge for the WTO. So what do you do given this sort of disequilibrium that existed between a legal process and a political process? I think we're in reflection, and this is where I've had to actually backtrack, the appellate body was much more stringent on interpreting import relief measures and constraining the application of safeguards, the application of anti-dumping. Chad mentioned the issue of zeroing, being stringent on countervailing duties, and so forth. Take anti-dumping law, for example, and this is the reason why it was Chad's fault and the economist's fault. We were all taught, right, that this is incoherent, right, that zeroing is nonsense, right, that this is just pure protectionism. It's not at all about fair trade, right? It's just protectionism. And I think that affected us. I think it affected the lawyers. I think it's what we taught. And so the appellate body came in and said, oh, these are not fair comparisons. And they found, a provision talking about making fair comparisons. And so they decided against the United States in a string of cases. And they were tough on safeguards, and they were tough on subsidies, and because they were concerned about abuse of the use of these exceptions. In retrospect, they should have been more like they were with respect to trade and environment and animal welfare issues. They should have realized that you need space, and this goes to Kristen's point, and the question is, what's the balance? It's not either or, right? Like more law or no law. My position is that in this area, this very politically sensitive issue of import relief law, countries needed more space. Why? Because we have very different economic models, with China's form of state capitalism, Europe's form of capitalism, US forms of capitalism. To manage this interface, the dispute settlement system, it should have provided more space than it did. In retrospect, it's easy to say this in retrospect, right? But it goes, of course, against everything that the economists taught us. Not that the economists were wrong in terms of their economic analysis, but in terms of the political economy analysis, I think this got us into trouble. So there you go. Back at you, Chad. The second issue, I think, which is central to both Chad and Kristen, is regarding the challenges that China poses. Of course, China is, I think in Chad's slide, the question is, why are not other countries bringing cases against China, given that China is the largest trader in the world? Brazil has brought a case, since Chad's slide. And that was a big deal for Brazil, because I interviewed them a lot and asked them this question: why aren't you bringing cases against China? I think there's multiple reasons, but one is that many countries exported commodities to China, not manufactured goods, and they did not have intellectual property goods, and so it just wasn't quite the same. They benefited so much from Chinese imports that it just didn't seem to make sense to bring claims. So that's the good side. Clearly, as Kristen has mentioned, there has also been the weaponization of trade. China has immense leverage over these countries. There's a fear factor, and that's undermining the dispute settlement system. Of course, brings us into a world that we're into today, where trade looks more like arms control. It looks more like the law of war than it does look like what we had before, which was a binding dispute settlement system involving countries' reciprocal bargaining and reciprocal understanding of their interests. And of course, there is the challenge of transparency within China. It's a fascinating issue, because once you go into China, you realize that there are debates about this within China. And there are clearly clashes between ministries, clashes between, the people who we know in China are generally the good guys, right? In the sense that they're actually putting pressure on Chinese ministries and saying, you can't do this because the WTO rules or so forth. You have to do X. But they're clearly not the most powerful ministries in China. We know that. They say that. They understand themselves. They will tell you the limits of their leverage. But that is a major challenge going forth. Transparency has got to be the central principle of the WTO if we're going to have a system of cooperation. And transparency is important not only internationally, but also domestically. And so I think I'll just end up there. I think, we're clearly at a delicate time with the trading system. I think there are three different visions of the ways to go forward. One vision is that this is the end of law. We're not turning this over to economists. We're turning this over to a political economist, and it's all about geopolitics, and trade has become like arms control. A second is we just need a lot more law. We need to discipline China. China's got to become more like a US model. We need to have more rules against subsidies and SOEs and so forth. I think that's not going to happen. Number one, I think it's probably, if there's going to be movement, it's going to not be inside the WTO, it's going to be outside the WTO. But I think there's a better way, which is to move the dispute settlement system and create an understanding that provides more space with respect to import relief measures, given the political sensitivities of these at the domestic level and the lack of a really dynamic legislative process at the international level.
All right, so a lot of very interesting things have been said. I would have liked to have 1 more hour to actually continue our conversation, but unfortunately we've gotten to our witching time, and we need to close here. I would like to thank Greg very much for sharing with us his book and and the main points about his book, and also both Kristen and Chad for some fantastic comments. With that, I'd like to invite you again to take a look at the book and to continue these conversations. Thank you all very much.
Thank you, Annabelle. Thanks, Chad and Kristen.